On July 21, 2010, the Dodd-Frank Wall Street Reform and Consumer Protection Act was signed into law by President Obama. He said, "The new law represents the strongest consumer financial protections in history." One key aspect of the new law focuses on corporate whistleblower rights. Specifically, the Act provides important provisions for whistleblowers to assist the government in policing securities fraud. I am here with Class Action Central Editor and Milberg partner Andrei Rado to discuss the new corporate whistleblower law and how it could change the current landscape for whistleblowers. Andrei, welcome. You recently wrote articles on the Dodd-Frank whistleblower provisions. Can you describe some of the enhancements featured in the new law compared to existing provisions?
Sure. Well, the existing provisions were basically in two places. There was the Sarbanes-Oxley Act that a lot of people have heard about had whistleblower provisions in there, but they were primarily to protect whistleblowers. They didn't give any reward, and the protections for the most part, and there were many reasons why they didn't really work. I'm not going to go into all of them. There was an administrative process set up for whistleblowers who felt that they had been retaliated against for them to go through.
Right.
It was bureaucratic and it didn't really work. So there was no reward. Okay. The other plan that existed was an SEC plan for insider trading. So if you're blowing the whistle on insider trading at a public company, under the old plan the SEC had discretion to give up to 10% of any fine, but it didn't really work. There were very few payments made under that plan, and they were not for a lot of money because the SEC had quite a bit of discretion. They basically could choose to give or not give anybody anything, and it just didn't work. So what's different now is that the language is much more commanding, and the statute says that the SEC has to give 10 to 30% of any fine above $1 million that results out of information given by a whistleblower. Okay, so as we all know, whistleblowers really risk their careers when they come out against a company that they worked for, and by giving them an incentive like that, I think it makes it much more powerful. SEC fines vary, obviously, but you know, they go from a few $100,000 to tens or hundreds of millions. There was a recent fine by the SEC against Goldman Sachs for I think it was $550 million. You know, 10% to 30% of that would have been huge. I mean, you know, you could see the CEO turning the company in for that kind of money. So I think that's something that will cause a lot of people to send in complaints, at least to the SEC.
Now, with the increased incentive for employees to expose securities fraud, does the new law contain any protection against employer retaliation?
Yeah, so the way the new law goes about it is by rewarding people and also protecting them. In addition to that, basically it outlaws any type of retaliation by an employer for whistleblowing. And unlike the old attempts under Sarbanes-Oxley, this time anyone who thinks they have a claim under the new act for retaliation can go directly to federal court instead of filing with the Department of Labor, which is what they had to do previously. In addition to that, under the old regimes, the employer could basically get around the protections by making any type of retaliation dispute arbitrable, and also by allowing them to waive it. And under the new Dodd-Frank Act, they can't do that. So there's no pre-dispute arbitration provision. They're not going to be enforceable, and you can't say, you know, the employer can't put something in front of them that says, you know, by taking this job, you sign away any claim you may have for retaliation.
Right. Right.
So I think it's very good, and it also doubles the remedies that you can get. Under the old Sarbanes-Oxley, you could have gotten basically reinstatement and the salary that you had missed while you were not working. Here, it's double that. So it really works, at least on paper, a lot better.
Okay. Now, in your opinion, what is the significance of the new law, and how will it affect shareholders?
Well, like I said, I think they're, as written, they're very powerful, and you would have to think that it would encourage people to come forward a lot more than they have in the past. And I don't know what's going to happen, but intuitively I would assume that the goal here would have been to prevent corporate fraud, to lessen the damage from corporate fraud. And I think if you have, if the SEC pursues it as aggressively as Congress clearly wants it to, then it will have that effect. And I think it could be beneficial for the equity markets and just the economy in general. I mean, if you think about the financial crisis, that was in large part caused by and exacerbated by fraud. There were many trustee reports and other reports showing that Lehman Brothers had used a number of accounting tricks to hide its real debt, the real risks that were on its books, and the same for AIG. I mean, you look at the financials, nobody would have thought that any of these companies could go bankrupt, much less overnight. So, the hope here is that a situation won't develop, or if it does develop, that it may be caught earlier in the process. So a Lehman would have been caught when they were overstating financials by 10 billion instead of 50 billion or whatever it actually was, and so on.
So if you're an employee at a company and you do discover fraud, what would you recommend would be the appropriate path to uncover the wrongdoing by the company? Well,
just speaking generally, because that's a very fact-intensive kind of question, the SEC has about 9 months from the passage of the Act to enact regulations telling people exactly what they need to do. But in the meantime, the Act is still operational, and the SEC has on its website a form that people can fill out. So basically the two big things someone has to think of is, do I want to go to the SEC by myself, or do I want to get an attorney to go for me? And obviously all the usual pluses and minuses of hiring someone to do something for you apply. The lawyer's going to charge you money, but doing it through a lawyer under the Act allows you to do it anonymously. So, you can make an approach through a lawyer and then see if the SEC is interested. Obviously, they have to keep everything confidential anyway, but some people may feel more comfortable knowing that the SEC doesn't even know their name, and the only time that the name would have to be disclosed would be right before they get paid.
Okay.
So some people may prefer that, but again, they don't need to get a lawyer. They can simply go to the SEC website, fill out the form, and say, I saw this or I saw that, and the SEC should respond to that.
Okay.
So those are generally the two ways to do it.
All right. Well, Andrei, thank you for joining us, and hopefully we'll have another Q&A in the near future.
Thank you.
For more information on the Dodd-Frank bill and the latest class action news, please visit our website at classactioncentral.com.